Additionally, we had reached out to DEP for some guidance on this, because we don't see these all the time. And they did concur that, those are a number of things that would be of concern. So the property has this Title V, and it's determined with these things to be in failure. So I did send a failure letter with an order to upgrade, and that's the letter that we received after that order was issued. So Mr. Patel has been very good about connecting with us. He originally sent this in January. As you know, we had the meeting scheduled in February. We had snowstorm. We had to reschedule. So that's the reason that it's here today. I believe Mr. Patel, the property owner, is.
Sure. Come on over, sir. Are you with someone else?
Yeah.
You are?
Gary.
You are, sir?
Gary from Lakeside Storage.
Okay. Did you want to come up too, or did you
Sure.
provide any testimony?
Thank you.
So you've heard, so the concern here is upgrade versus variance? Is that?
Yeah, so
understanding correctly?
upgrade is what we're requiring.
Okay.
And that letter is in your packet as well. The order that was sent to Mr. Patel in December.
And Mr. Patel, hearing the testimony from the town and stuff, what would you like to say?
Yeah. So my name is Apu Patel. So we bought this property, I think, in somewhere in May or June last year. It was a foreclosure. So the gentleman who owns that, he was staying in the house probably until November, and then he moved out. So until November, he and his wife was occupying the house. So they were under the eviction process, and then they voluntarily moved out. So after that, we get the Title V report on that one. And then we heard about the report, and that's why we reached out to the town requesting the variance on that.
Is this your home?
Yes.
And the issue is just, again, it would be requiring an upgrade because of the setback, or?
Right, so, again, as part of the, on the actual report, there is a, I'll show you on page 4 of the report. It does have, system will fail unless the Board of Health and a public water supplier, if any, determines the system is functioning in a manner that protects public health, safety, and environment. So it does have, system has a tank and an SAS, and the SAS is within 50 feet of a private water supply well. Again, we didn't get the well test with the Title V when it came in, but Mr. Patel did, after speaking with him, he did have the well tested. I think you took the sample yourself, correct?
Yes.
And then you, so he took a water sample after, I kind of talked about my concern of the private well that serves the dwelling is 33 feet from the septic system. So that is obviously a concern. There is a well test that Mr. Patel, the owner, took. Normally, water tests for new wells are taken by like a well company, certified well driller. But in good faith, I think he wanted to show that, there wasn't a problem with the well. But I think overall, for the lot is challenging. I do recognize what he's saying, and he does provide that contour map for you. But it is a decent sized lot, so I think you have like a
It's a
1.5
3 acre.
acre.
Yeah,
Oh, is it
around
3
3 acre, yeah.
So it is a large enough lot that, you know, if a system upgrade was going to, you know, be recommended by the board, there is room here. The land is challenging, no doubt. But going forward, if the system was or has not received normal flow in that time, that's a concern. Once it starts getting normal flow, is the well still going to be okay? Normally, these come in and we review them, look at the criteria, go through the inspection report, and quite honestly, I do reach out to DEP when I have concerns, just because DEP typically sees more of these type of examples because they provide advisement for more than just one town. And they did concur that the board was looking at valid concerns. Obviously, it's up to the board whether or not you agree with the determination that we're requiring an upgrade to the system. But I think the part that's difficult for me is if the system was originally built with the house, so back in the 80s, so obviously that's a significant amount of time. But there's no like maintenance records, so we don't have any pump slips. We don't have any, they obviously did some sort of work where they replaced the D-box, and we don't have any permits for that. So at some point, they had to replace the D-box because of something happening with the system. So what happened was, the field may have been overloaded, backed up into the D-box, or the actual D-box just may have disintegrated over time, because that does happen. It's a series, it's not just one thing, it's just a series of concerns. So I wanted to, just bring that to your attention. We did literally just get, within the past couple of hours, we got something from, advisement from the state, and they also identify the no normal flows as a concern. The D-box replacement without the permit, so that something caused that to happen. And then the estimated high groundwater from plans and specs from adjacent lots. They recommended kind of looking into what how those were determined. And then they also do call out variances for Title V. So the variance request for Title V is granted when you design and upgrade a system. So variances and local upgrade approvals happen in the process of you doing a design for a system. So if it's a challenging lot and it's, this would be, if Mr. Patel was to upgrade the system, it wouldn't be a brand new system, it would be a system repair. So there's certain adjustments that can be made under Title V that allow for that. So that would be, a variance or an LUA. So I point that out just because, again, we don't claim to be the only know, the only ones that see Title V systems, but we do try to lean on advisement from people that do see these type of systems. Happy to answer questions.
Yes, sir. Okay.
Can I ask some questions
Sure.
or make some comments?
Sure.
I mean, the reason for further evaluation for this inspection is strictly because of where the well is located. I'm assuming when we're mentioning upgrades, we're not talking moving the well, we're talking replacement of the septic system. Am I correct on that? Is that what you're thinking?
System upgrade, yes.
See, but there's nothing in that report, and I've also spoken to the inspector, there's nothing wrong with that septic system. D-box replacements are common, and it's always due to the cement falling apart. The gases will destroy the D-box over a number of years, and its replacement. I've never replaced a D-box because it was backing up or something like that. At that particular point, it's an upgrade. Why would you spend money on replacing a box when the system's not working? But I did question the inspector. He said everything on that system is working fine. There's nothing wrong with the system which would require replacement. The well is the problem, and that's why it's under further evaluation. So I just feel we're going a little too far when we're condemning the system when that's not the purpose of the Title V inspection. It's to point out what's there and what the conditions are. You have that. So I don't understand why we're going for system replacement. I understand the questions about the well. It is closer than normal. I mean, the minimum is 50. If it were 50 feet away, we would be doing just testing, water testing, and we would be passing it as a Title V inspector. That's all. So what I think we're looking for is what flexibility do we have? What do we have to do in order to keep the town happy? We tried with the water testing to prove that the well is not being contaminated by the system. I'm not sure, once a house goes vacant, do you know how long it was vacant?
He moved out on November, first week of November,
And the
so
Title V was done in November, so I would think if the well was being contaminated by the septic system, that contamination would last for quite a while. If it was vacant for a year or two, maybe I would think then, yes, it would clear up. But no, I just,
the gentleman still lives in the town, so if you want to speak to him.
yeah, I don't
he
think
still
there's a
is-
question that the system isn't working, it's the well, which is an issue to deal with.
Is that accurate? Is that, like, is the system, do you agree that the system, that the sewer is, because I didn't see anything in here that the sewer was faulty. Is it more of just kind of, it came to us and we see the setback with the well?
Yeah, I mean, obviously, the Title V, you know, the Title V is identifying the well is really too close to the field, so the soil absorption system. Just for reference, like for a new system, you'd have 100 feet from the private well to the new SAS, soil absorption system. With existing conditions, it's very, I'm not gonna say it's not common that you would see tight lots that have, you know, wells that are closer. This property is large, but they do have a slope, obviously, to the land. So, again, it's not just the one thing. There's several things in the report, and based on what we have on file, we don't have any records of the system when the date it was installed. We don't have any pumping records, no records identifying that it was maintained over the years.
What would that be? Why, how come? They just didn't give it to us?
Right,
or- okay.
no, but if the owner didn't have the system pumped by a licensed hauler, we don't have any records of it. So haulers that are licensed, they're required to send in pump slips to the town, and we log those pump slips. One thing that I also wanted to point out to you, this area of town, I am familiar with, and we've had system upgrades in this area. So Mr. Patel owns 650. We do have right next door to him, we have a passing Title V report in 2020. And on the other side of him, we have a system upgrade. So there was a system upgrade right next door to him and a passing Title V right next door to him. We have a vacant lot that has a brand new system that's designed. We have several D-box replacements further down the line. We have properties that have routine pumping with pump slips. On the other side, we have another conditional pass on a report. We have a system upgrade for another property and a passing Title V from 2017. So this area, I do have some knowledge, and there is different situations all around this property.
And, I'm sorry.
No, please, yeah, please.
And you did note that DEP had concerns?
So DEP, we had reached out to provide input, to identify, like, are we looking at the right items on the report? And they did concur. They actually said, absolutely. So I wanted to make sure that we're giving you, I certainly respect, I'm sorry, Gary, what's your last name?
Gary Lind.
Lind. I certainly respect Mr. Lind's experience, and I think it's, it's not just one thing, trying to look at the whole picture and trying to err on the side of caution to protect public health. This property is also across, I think on your picture you have it. It does have a water body across the street, so just for reference.
So in reading the Title V inspection report, I do see that now, is that it will pass, however, it is kind of with the well within 50 feet. So if I'm hearing you correctly, Mr. Patelli, you would want the system upgrade would be financially not possible?
Financially as well, and looking at the topography of the lot, I don't think that there is any option to do anything on that one, because that is the whole lot is complete ledge.
What about a well? Is there an issue with putting in just moving the well?
No, that is what we were trying, so that's what I already get the couple guys that to check on that possibility, because this well is over 200 feet deep. So they do not see that, because there is all on the left hand side of the dwelling is all the ledge. That is the same thing on the back of the house too. So they see that they might have to do the blasting or that kind of thing. So it will be hard to get the well moved. Otherwise, that would be an easy solution.
Do we have any reports that say that that's who are the folks you can talk to in terms of well drilling companies and stuff?
There is one in Charlton, I think. The gentleman, he looked at that.
Did he provide you with any type of report or anything?
No, I just talked to them about the situation, that what is possible. But that time there was a lot of snow as well.
Okay.
So
Children, have any other questions or?
but I spoke to the previous owner about this situation, and I asked him that he has any problem, because he owns that since '95, so he probably live in the house for almost 30 years. So he said that we never had any problem in the septic, and he said that our quality of the well water is so good that my friends were taking the water from the spigot outside. He put for the water, and they were still using that water to take their home.
Mr. Patel, do you know if the previous owner, did they ever had it tested? I know it probably tasted, well water has a certain taste, but did they ever have like quality testing that you
No, I
could?
don't think that
No.
they have done that. But I asked about that pumping, so he said that we were doing the pumping, and I mentioned him that when you say that you don't have any record on that
Right.
one. So he said that why the town doesn't have the record, I don't have any idea, but he has done that. But he said that like last over a year after he was in foreclosure, I think he has not done that, so.
Right.
So probably around a year, that is what he mentioned. But he said that I don't know that why it is not been reported on the town.
Right. I mean, do you know if, because typically, I guess in my experience,
Mhm.
when there is like if somebody has a septic system and they're having it pumped regularly, they're using sometimes the same professional to do
Right,
the
yeah.
Title V. And I don't know if L&H identified to you or to Mr. Lind whether or
No,
not they
we
pumped the
just,
system.
No, we just find that, we look at the Google and we just contact them, so.
Yeah, okay.
So that's, so that time I don't think that it was gonna be that kind of serious, so I thought that it is a routine process, so we just pick
Right.
one and just call them and they did that, so.
Yeah, no, the reason I say that is L&H is a professional that does a lot of work in town, so they do, I didn't know if they offered any insight on pumping.
No, they don't have any information on that.
Okay.
So,
And from the well companies that you spoke with, there's no other option of putting
no,
that?
they said that
Wow.
it will be hard because of the rock and the ledge that the whole lot is like that. All this 3 acre, the whole lot is quite high than the road. It is at least more than 50 feet high. The whole lot is more than 50 feet high than the road. And that's all rocky, complete rocky. So that is so hard that we are trying to get the subdivision on the lot. It is 3 acre, but it looked like that to make another driveway is not gonna be feasible because of the rocks. It is that much rocky. So we dropped that idea, doing the subdivision as well.
I noticed on the report that they said it was in good condition, not leaking, no filter, recommend yearly pumping. And what is that, the inlet, rise or degrade on inlet? So is that a recommendation?
That's a recommendation, just to provide easy access, because every time we go out to do a pumping, if we have to dig it, there's a labor charge. So you eliminate the
Okay.
labor charge for all the years
I
to
see,
come.
so it's not really related necessarily to the function of
No,
the subdivision.
And it just, if you're in the wintertime when it's frozen, it gives you easy access.
I see.
But he do that, he put the cameras in and
Yeah.
he did that things because he called me for that because there will be an extra charge on that one. So he told me that he need to do that.
Yeah,
So I allowed that and then he did that. So he like put the cameras into the field or whatever, how it works. So he has done that as well.
And that was the reason I wanted to call the inspector himself and talk
Yeah.
to him, just to see if it was a borderline type thing. Did he see
Yeah.
something that would question it, such as severely poor maintenance and that there was a lot of sludge in the runners or in the leach lines themselves?
yeah,
And he said it actually looked really good.
yeah, I see that, yeah.
So how does this thing begin, I guess? Like, how did this all come?
So this came about from the Title V. So the Title V report came to us.
Okay.
The Title V was done in November. We received it. We reviewed it. And I have to say, you know, with the well being that close, I did have concerns. I reached out to DEP for advisement. I spoke with the inspector. I spoke with Mr. Patel. And understood that there are concerns regarding the system. So that's what this order to the owner is. So due to the existing of all these concerns, the system has failed. So that is the determination I made based on the conditions in the report and the overall not having any records, any maintenance, the D-box replacement without the permit, overall.
If we were to get those, would that change?
Well, we don't have any, as of when this report came in, those were not,
What about
Those are not
what
part
if
of
the
it.
previous owner had them?
No, he don't have that. I already
He
reached
doesn't
out to
have
him.
that.
I spoke to him. So
He had
he,
these houses.
yeah.
so he was saying that I can, if you guys need anything, you know, he can give that in writing. So he was ready for that. So he said that I can, or we can call them, and you know, he's not in good health now, but I believe he still lives in the town.
I mean, I think the proper answer to your question is how did this all come about? It's because of the well.
Yeah.
The well is the triggering factor for further evaluation. That put it in the Board of Health's lap to determine what to do with a well 33 feet away.
Admittedly, I'd be more concerned if the inspector was kind of finding issues with the SAS, but there doesn't seem to be really any issues, other than I understand no clear documentation of maintenance, but it doesn't, the inspection at least doesn't, you know, reflect that has been detrimental.
Well, the other thing too with an upgrade, I mean, I looked at the lot, but we didn't do any testing to see how bad the ledge is. It may be the only spot for that septic system is right where it is.
Yeah.
Some lots are that way, that there's
Yeah.
just very small area that's not full of boulders and ledge. So even with an upgrade, it's still gonna throw it right back into the well location is gonna be the problem. More than likely, I don't think the system can be moved very far from where it is.
I was thinking the same.
Yeah, it's difficult.
Because the height difference is too much to see, like, it is a steep height
Yes.
where the septic tank is, and then the next area is like below 50 feet
Right,
yeah.
near the road. So that's, the lot condition is kind of very,
Challenging.
I mean, I think it might be helpful to know if, at least for the board and just overall, of knowing what that cost might be to, if the board can overrule my decision to, you know, to call this a failure, and they can accept it with your well test results, so that is an option for the board. But I guess going forward, like the concern for somebody, if Mr. Patel chooses to sell the property to the next person, like the concern is making sure that public health is going to be protected. So making sure that somebody understands. It sounds like maybe the people that live there never experienced a problem, but they may not have known if there was anything wrong with the well, if they didn't test it. If the cost of like a quote to move the well, it sounds like maybe you had the well company come out in the winter time, which obviously is going to be challenging anyways. But that could be something that the board could consider. You could continue this until the next meeting to allow the property owner to get a quote on moving the well. That's one option, or you can accept this as passing. You know, that's your right.
So the rough estimate the guy was talking about is 20 grand plus, so for the well,
For what now?
for the well,
To move it?
to move the well.
What about like actually testing it?
Testing for,
The well or any other formal testing to be done, like you had mentioned?
Right, so the water test, the well test that Mr. Patel sent in, it's a test that doesn't show any nitrate or nitrite, no coliform, so it's basically a passing test. But, you know, obviously he took it himself. It's something, if the board wanted, you can have, you know, a third party can hire a lab, certified well driller, somebody to go in and take the well sample so that, you know it's coming from a professional sampler, and have the well tested, so that, you know, there's a chain of custody that comes with it, so that you have an understanding that the well test is done, and that you get a result that's not biased.
Yeah.
You know what I mean?
I do.
I mean, that's an option for you.
Would that
The other-
satisfy the concerns with the, you know, no records, no permits, no pump slips? Would that,
Well, that's not gonna satisfy like the septic part of
Okay.
it, but it would satisfy the fact that, the well has been tested professionally.
Yeah.
Mr. Patel, do you live at the property?
no, not yet.
Okay. Are you
Where?
intending to? I know you
Yes,
pulled a recent
eventually.
building permit.
Yeah.
Now, is there also something that we could possibly get from a sewer professional that says there is absolutely no other place on this lot that this system can go? I think, so you had mentioned that as, you know,
Yeah,
sometimes.
I think that would have to come probably from an engineer, and they would go out with, I think a visual first, and I don't know if they'd have to bring in equipment to do some testing. I mean, the topo, it really does skyrocket from where that well is. You go 5 feet beyond the well and it's 8 feet higher, and then it just continues to go up. So I think it would be an engineer. I wouldn't want to try to guess where that ledge is. I'd want somebody with a little more experience in topography, and I forget what you call it when they determine what the stratus of the soil is and how much rock it's. But even, I don't know, I think maybe if you go with further testing for the well, verify it and make it a requirement that the well be tested every couple of years, or the other option, I agree, would be to remove the well. I'm just opposed to replacing the system without something more. I mean, I do Title V's all the time, and I was on a system today that had not been serviced in 30 years. Granted, a lot of the resident that was there was an older person, it was an older couple. The husband passed away 10 or 15 years ago, she was alone up until now. The system flew through title. So you never know. And then I go to one that's 10 or 12 years old, sophisticated system, and it's in failure. So there's just so many variables. So the maintenance, I think it is important. That's what I do. So I'm not going to say maintenance isn't important, but it's not. Systems still pass without the maintenance, and some ended up being replaced. And I did not inspect this system, so I can't, but what the information that the inspector that did it was all good information, and I think he went, did a very good inspection.
So, kind of kind of recycling here, so the actual septic did pass, the Title V did pass. It's the problem with the well, that is, it's because it's just not far enough away.
Yeah, so I mean, the further evaluation comes in because there is one of these items here that gets identified. So.
Then that being the well, correct?
Yep.
It's not, okay.
Yes, so that, along with the other items, is obviously, where we had the concerns. But certainly it's the board's prerogative. If you feel like it's something that you want to accept as passing, you can put conditions on it. That's one option. You can require testing to be done every couple of years. That's another option. The only thing that I would caution on that is something that the board has done in the past. It's very difficult to follow that.
Yeah.
So you have to kind of put it on the owner that, it's a strong recommendation from the board that you test your own well so that you are drinking safe water.
Maybe for the, this initial approval to have a professional
Right.
do the actual testing. I mean, not that it didn't, but
Right, sure.
to get the sample.
The other suggestion that did come up with the state was that if the board wanted to have a Title V done again, once the system received regular flow after 6 months, that's another option. But again, those are all things that are options to you. You don't have to take any of them. You can accept it the way it is. You can require the well to be moved. You can require well testing. It's really, hearing all the facts and hearing the, the input from the professionals to give you that information to make the decision.
Any board members have any other questions? So I think that with the Title V and hearing that you do these all the time, you did a thorough inspection, the inspection is there, the system is functioning, it's just the location of that well is the problem.
That's
We
correct.
do have a passing water sample, however, it was taken by the homeowner. So I think I would lean towards having someone come in and actually just test that well professionally, a third-party independent come in and test the well. That would make me feel a little bit better with that. And the only thing I'm questioning now is, is there, like, as far as an engineer coming in and being like, yeah, absolutely not, this system can go no other place but where it is, would that be an option?
So the engineer, I think, I talked to them, and so they want to charge like 5,000 plus, so they charge with 5,000, and then that will be the additional charge. So that will be quite a burdensome as well. So they're not cheap. So I thought if it is couple $1,000s, I can get that done with them, So that was in our mind, because that's what Mr. Lin told me that time, that could give the board more satisfaction about the situation. But if that is required, then we'll have to do that. But it's a kind of too expensive,
Thoughts from the board members?
I would be comfortable with, like a professional well testing company first, and before granting this, and then, well testing every couple of years. I understand that it's, hard to follow, but
So would a suggestion be that we table this and then we get a professional well sample done
Yeah.
from the well tested, and then
Yeah.
reconvene?
yeah.
Yes, I'm
Is
comfortable with
there a
that.
motion?
I make a motion to continue the hearing until we have a third-party
Professional well test.
professional well test.
We'll
To
do
do-
chain of custody.
Yeah,
And is there a
I
second?
second the motion.
All those in favor, if you can signify by saying aye. Carolyn Griffin,
Aye.
Kara Westerman.
Aye.
Eric Otterson, aye. Okay. So we'll get that professional water test from a well with chain of custody, and then we'll reconvene at probably our next meeting. I don't think and then we'll kind of revisit the whole thing and hoping that water sample comes back and it's clean, and we'll have to kind of reevaluate. In the meantime, if you can come with anything else from anyone in regards to like citing that system and stuff, I think that might be helpful as well.
Any type of supporting documents.
I get that, yeah. Now, this, like the third party, so that the board will recommend that, or we
So-
get to do that, how, who?
Yeah, so we can connect Mr. Patel. I can give you advisement on the state website. There
Okay.
is certified well drillers
All right,
that are certified from the state.
Oh,
So you
okay.
can go through, I can tell you where to find those.
okay,
The difference is they want the testing company to take the samples, so that
oh, the testing company,
Yeah.
so the laboratory can do that too.
we won't be involved other than you opening the building to let them in.
Oh, okay.
So that way you get the chain of custody.
So this laboratory in air, they can send their guys and,
Yeah,
okay,
yeah,
yeah, so,
yeah.
but that is acceptable,
The
right?
professional
Yes.
Okay, yeah,
labs, yes.
so we will
Yep.
call them, yeah, so that should be fine, yeah.
So if you want to connect tomorrow, we
Sure.
can,
We'll do that.
sure,
Yeah, no problem, just want to make sure that how you want, so.
sure, yep.
So make a motion to close, continue, as you said. Oh, we have to do that again. We've already did
No,
that.
we'd close the
Yeah.
hearing and
Oh,
and
okay.
so.
So I'll make a motion to close the hearing.
No, we'll
continue.
we've got to continue, so we're good.
Yeah,
Okay.
okay.
Great.
Thank you for your
Great.
time.
Thank you so
Thank you
much.
very much,
Thank you for
appreciate it,
coming.
thanks.
We'll talk to you soon.
Next on the agenda is 6:15, where we're quite late on this, my apologies, is a dangerous dog violation for 29 Cedar. So we do have, this hearing, I do have a script that I will need to read for this. So for the purpose of the hearing, the board is hearing evidence considering a conditions of a dangerous dog, and to make determination as to what action to take, if any, regarding the dogs involved. The board will hear representatives from the town that have been involved in the investigation of this matter. The board will hear from residents of the town and other witnesses involved. The board will then give the dog owner an opportunity to speak if he or she chooses. The board will then continue or close the hearing or make its decision as to what can be done in this case, and will issue an order accordingly. We will first go with the town witnesses after being placed under oath, and then others, and then also the complainant will go after that. So I will swear everyone in now. So those who are testifying on behalf of the town,
Yep.
Okay, please raise your right hand. Do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, so help you God? Thank you. And those who are, anyone present in the, you are. And if you'd come up, please, and just state your name for the record. And then I have a Matt and Christina LaValle. Can you turn a camera on, please?
Oh, sorry.
I need to swear you in.
Can you see us?
Yes, I can. So those who will be testifying, so I have Matt and Christina LaValle. And ma'am, your name?
Amy Akoshes?
Amy Akoshes. Is that for this hearing at
Are you
Cedar?
here for this hearing?
Yes.
Okay.
I mean, I can speak as a
No, I
member
didn't know
of
if you were the dog owner.
citizen of the town. No, I'm not the dog owner.
Okay, okay. So I'll have then yourself as well as the LaValles raise your right hand, please. And do you solemnly swear to tell the truth, the whole truth, and nothing but the truth, to help you God?
I do.
Thank you
Yes.
very much. You've all been sworn in. Excellent. So we will now go to the town witnesses in regards to the hearing.
First of all, I just want to say sorry, I'm still working, so that's the text in between everything. I apologize. I've got animals coming in and out, and I'm just trying to make sure everybody's okay. So going forward, we had a hearing on March 17th after Faith had bit the next door neighbor. We did an order, and since then, the order has not been followed. Faith has still not been licensed with the town. The violations have not been paid. I have been trying to work with the owner, Miss LaValle. We have two LaValles, so it's no relation, just same last name. So Justine is the owner of Faith. So Justine LaValle. She did just get Faith vaccinated. I have not seen the paperwork yet. Hopefully we'll get that in. Hopefully we'll get her licensed. There are pictures that Matt and Christina LaValle had sent in to show Faith outside. At one point she was loose in her own yard. And then another point we have Faith out at the end, very long driveways, at the end of the driveway at the street, which unfortunately is where their young children get on and off of the school bus. So I'll let them speak to, the concerns. So we do have those pictures if you would like to see them.
Are those in our packet here?
Unfortunately, there are some in there. Those ones that you did get are Faith loose in her yard, and these are Faith loose by the road.
Gotcha.
So I apologize, that was my oversight.
That was, I just, what
I think those were doubles in there, I apologize.
Gotcha.
So just clarification from me, because they both have the same name.
Yes, and that's why I'm saying, so
Right.
Christina and Matt have the son that got bit by Faith.
Okay.
And then Miss Justine LaValle is the owner of Faith. So
Okay.
that's why I am referring to
Yes,
first names
yeah,
as well,
yes.
so you're,
No, thank
because I
you.
get confused
I-
too.
Yeah, I appreciate you
No.
explaining, defining that.
Sure.
Is there anything else that, other than what you've sent as far as the order not being followed, not licensed, not paid violations? Has the owner reached out to you in any way? Have they been responsive to you in any way?
I have been in contact with the owner. It was a little difficult at first. The first complaint that came in was January 1st. And that was the photo, I believe, with Faith loose in her front yard. And then Christina has been trying to work. They are neighbors, nobody wants to see anything negative. So they were trying to kind of work together. Unfortunately, on February 5th is when it took place again, and the dog was outside near the bus stop. Like I said, I don't want to go into too much detail about their feelings, but I know the concern is kids at the bus stop. So besides those two things, just a communication with Justine, it took me a little bit to get a hold of her. So we ended up speaking about a month ago, and that was, I was, reminding her, hey, we have these orders in place, we have fees that are due, we have to get the dog up to date with rabies. More than anything, it's that rabies, God forbid it would ever happen again. That's my biggest concern. So she did let me know that money was an issue. So I said, okay, just get the rabies shot for me.
But you still have no documentation.
Yes, I'm waiting for the documentation. So hopefully we will see that soon. I did go to Justine's house again last week to hand deliver. We hand deliver, certify, and regular mail. And while I was there, we did have a fairly lengthy conversation. She's upset, she's having a hard time. She's saying that the dog bite took place on her property, and that's why I really urged her to be here tonight. I'm still hoping that she does come. So now she's at the point where she's saying she does want to surrender the dog. She is not happy with everything going on. The dog likes to run. She is a German Shepherd. She's got a lot of energy. She wants to be out. She wants to be running. My concern is if the dog gets surrendered with a bite history, And the little moments that Amy and I had seen when this first took place, Amy Contois was still the ACO, so we had gone out together. We were in Justine LaValle's garage, and Faith did come running out of the house, up, paws on Amy's chest, nose to nose. Gave us a little scare. Amy, fortunately, did what she was supposed to, stand still. She did recall her. Everything was okay. I'm just not sure if we do have her rehomed, what the outcome is going to be. I'm not sure if she will end up being euthanized. Not many shelters or people will take a dog that has bite history, and she does have this dangerous dog order, so wherever she goes in the state, the order follows her. They have to be notified. I don't know if you want to talk about other options or you want to wait for that.
I think we'll wait for that. Is that the end of your testimony in regards to this? And the complaint will be last. Miss, in your involvement with this?
Concerned citizen of the town.
Okay.
Is that acceptable?
Yeah, and I'm sorry, I didn't catch your last name.
Atkocius, Atkocius.
Okay. And are you an abutter of this property at all, or nothing? Okay, okay. What do you have to offer for this?
I wrote a statement, and I hope I can be able to read it. Is that okay?
Sure.
I'm not a very good public speaker. I'm sorry. So, good evening. I want to begin by saying to the LaValles, those LaValles, that I'm sorry that you're here tonight. I'm sorry that there was a first hearing, and I'm sorry that there's now a second one. You have been dealing with the situation for a long time, and you deserve a resolution, and I hope that tonight brings you closer to one. As to the exact nature of tonight's proceeding, it's not fully clear to me. I'm hearing all this for the first time, so I'm not going to comment on it. And instead, I'm going to focus my remarks completely on the March 17th, 2025 hearing, the process that led to it, and how it was conducted. And I would suggest that had the LaValle's concerns and the incidents they documented been handled differently from the start, they would never have had to attend one of these hearings at all, let alone two. Understanding how the first hearing came about and how it was conducted is, I believe, the key to ensuring that there does not need to be a third hearing. To understand what happened, it helps to know how the town's own bylaws structure this process. Under Section 1212(5)(a) of Auburn's general bylaws, what I'll call Track 1, the animal control officer has independent authority, without any hearing at all, to investigate a complaint, issue non-criminal violations, impose binding conditions directly on the owner, and make a determination that a dog is nuisance or dangerous. Those conditions can range from least to most severe: mandatory fencing, mandatory training, on-property leash requirement, muzzle requirement, and in extreme instances, rehoming or worse. All without a hearing. If the owner refuses to comply, the ACO can escalate the matter. The hearing under Track 1 is a last resort, reached only after the ACO has tried and exhausted her own enforcement tools. Under Section 1212(6)(a), Track 2, any person, including a private citizen, may file a written complaint directly with the Director of Public Health or the Police Chief and initiate a public hearing themselves. Now, knowing that those two paths exist, consider what the LaValle's were actually told. Writing in response to yet another off-leash encounter, ACO Contois described the public hearing process in detail and closed with, "If this is a path that you and your family decide that you would like to pursue, it would need to be initiated with a request in writing to the Board of Health." That was the entirety of what she offered, a hearing, if they chose to pursue it. No mention of her own authority under Track 1 to act unilaterally, impose binding conditions, require vaccination, compound daily fines, mandate training or fencing, require on-property leashing, require muzzling, etc. Is it any wonder that, having been told by the town's own animal control officer that the only path available was a public hearing, that the LaValle's chose to pursue one? They wanted it to stop. and they didn't know there were other options because they were never told. And neither, it appears, was this board. With that context established, consider what the owner of Faith received in advance of the March 17th hearing. Adequate notice is not a procedural nicety. It's a fundamental right in this country. Consider something as routine as jury summons. That document, which asks far less of the recipient than a dangerous dog hearing, nonetheless clearly states the relevant statutes, the nature of the obligation, and the consequences of noncompliance. The owner of Faith was handed a piece of paper that said dog hearing, 5 days before a proceeding that would result in a permanent public determination about her property, her animal, and her legal obligations. 5 days. That was 2 full working days. What if, on the evening of the 17th last year, she had to work? What if she needed time to find counsel, gather documents, or simply understand what she was facing? That is not adequate notice by any standard. And nowhere in that notice did the word dangerous appear. It contained no date of the alleged incident, no description of the nature of the hearing, no identification of the governing statute, and no statement of the consequences of an adverse ruling or non-attendance, and indeed did not even request her presence. The agenda listed it as a dog hearing. The minutes record it as a dog hearing. When Chairperson Otterson called it to order, he described it not even as a hearing, but as, quote, the Cedar Street dog complaint. Massachusetts General Law, Chapter 140, Section 157, the statute the town's own bylaw explicitly requires these proceedings to follow, was never mentioned. Not in the notice, not in the opening, not anywhere in the transcript or in the minutes. The board's own dog hearing procedure script, which Mr. Otterson read tonight, which was in the packet for that hearing, requires the chair to announce the purpose, state specifically whether the proceeding is a nuisance or dangerous dog hearing, and explain the procedure and possible outcomes to those present. None of that was done. And it is worth noting that there is no mechanism built in for the respondent to request more time, even when notice has been as limited as it was here. The packet provided to the board contained the LaValleys complaint, their history of the dog, photos, and the town's enforcement history. It did not contain the town bylaws, the document governing the very proceeding being conducted. It did contain a reference to MGL Chapter 140, Section 157 within the ACO's recommendation materials. That statute was available to the board. It was not provided to the dog owner, who was never told it applied to her, never told what rights it affords her, and never told she had the right to legal counsel. I would ask this board to consider, is it not entirely plausible that when the owner of Faith received a notice saying dog hearing just days after receiving her first citations, and I'll come to that point in a minute, she assumed that she was being summoned about those citations? The notice gave her no reason to think otherwise. But let us also consider the possibility that she did understand, despite the deficient notice, exactly what kind of hearing it was. If so, she would also have understood that the outcome was likely a foregone conclusion. Given the dog's history with the town, a bite report, and several off-leash incidents for an unlicensed and unvaccinated dog, a dangerous dog determination was the probable result. We need only to look to the 2019 Church Street hearing put before the same board for comparison. In that case, a dog bite...
I need to stop. I need you to we need to be on just this hearing here that we're talking about. This hearing in the March 17th. If you want to go to the March 17th hearing and focus you, but we're dealing with this Cedar Street incident. We can't go into the previous histories of any of these. This hearing is open for the purposes of the Cedar Street incident. So I need you to limit your testimony to that.
Okay. I mean, Does everybody agree with that?
Well, that's why we're here. This is a Cedar Street meeting. We're
I
not gonna go through every dog hearing.
I'm not going through every dog
I didn't
hearing.
say that, but where this hearing is opened for the purposes of the Cedar Street non-compliance hearing. So I need you to focus your testimony on that.
Okay. Then I'll skip that paragraph, and the only last thing I'll say is that thankfully that hearing happened in 2019, when the town was more careful about what sensitive information was posted online and in a way that gets indexed by search engines. The personal details that owner shared about a difficult time in her life do not appear when her name is searched today. Held under today's practices, that would not have been the case. It is completely understandable that the owner of Faith, even if she grasped the nature of the March 17th hearing, might have concluded that her best option was to keep her name off the official record as much as possible, to not stand before a public board and describe circumstances that would be documented indefinitely, appearing in every future Google search of her name or her address, especially when any sort of leniency from the board would have required airing her personal circumstances. This is not an unreasonable calculation. It is the calculation that Track 2, the path the LaValleys were sent down, forces people to make. And it is one more reason why that process was not only the wrong tool for that situation, it was a nuclear option deployed before any of the more measured tools had been tried. A determination reached through a deficient process is not only unjust, it is vulnerable. The owner of Faith had straightforward grounds for appeal of the March 17th decision, and it is something of a founding principle in this country that people do not comply with rulings that they believe were not reached fairly. The right process, done correctly, would have given the LaValleys a much stronger and more durable result. Now let me turn to the packet the board received for the March 17th hearing. I have genuine confidence in the judgment and good faith of this board. I believe that the members had adequate time to review the March 17th packet thoroughly before that hearing, several things would have stood out. The violations for failure to vaccinate and for an unlicensed dog were dated March 3rd, 3.5 months after the November 19th incident, when the town undeniably knew the dog was unlicensed and unvaccinated, and notably after the LaValleys had already formally requested the hearing. The sequence matters. The LaValleys asked for help, were directed to the citizen-initiated Track 2 hearing process. They filed their written request, and only then did the town issue the citations. Those citations appear to have been assembled to populate an enforcement record for the hearing, rather than as a genuine attempt to compel compliance. And the total fines issued were only $100, which, as a deterrent, is laughable. And at the time of the hearing, they were not even yet due, despite documented incidents months earlier. Had the town bylaws been in the packet, the board would also have been positioned to evaluate what the ACO told them during the hearing. At the outset, she stated, "Up until this point, we can't take any action other than education to the owner, which we've tried, citations, which we've tried, so this is the next step in the process." And in explaining specifically why the hearing was necessary, she said, "Without an existing order, we don't have any way to enforce that Faith remain leashed on property." What she did not tell the board is that she had the authority under Track 1 to issue exactly that order herself, without any public hearing at all, or at the very least, without the LaValleys having to initiate a proceeding against their neighbor. The determinations made by this board on March 17th were perfectly within the ACO's own remit to implement directly, without a public hearing, without neighbors testifying against each other, and without a permanent public record naming the LaValleys as the parties who brought the case. Now, I have nothing but sympathy and kind words for the LaValleys. They seem like genuinely good people, maybe a bit too nice. Before the November incident, they could have gone to the ACO with concerns about an off-leash, unvaccinated dog. And perhaps they did, but it wasn't in the record. They could have pushed harder for the ACO to take remedial measures, because it is absolutely within her authority and, according to animal control officers I have spoken with, simply part of the job. But they didn't, because they were acting in good faith, following the instructions given to them, and trying to be good neighbors. When they did go to the ACO, they went repeatedly. They sent video. They documented every incident. They did everything right within the process they were given. They were told coming before the board was the only way, and they did that too, starting a public proceeding against a person they lived next door to. They were never told about the other avenues for enforcement. Neither was the board. In fact, quite the opposite. Both the LaValleys and this board were told that this was the only way. I looked at the property on a map. These are two households sharing essentially a private driveway. They cannot avoid each other. That makes what happened here, neighbors being put on opposite sides of the public proceeding, not just procedurally problematic, but a real and ongoing harm to people who have to live side by side every day. I want to keep going, but you're probably going to object to what that part, okay? Can I try?
You can try,
Sure.
again, I would
Okay.
like you to remember my previous instruction was to stay on this particular matter.
So it's worth stepping back for a moment and asking how other communities handle situations like this,
Okay, I'm going to object to that.
okay? I would just add that typically no, I don't want to get in trouble. Before I close, let me leave this board with a concrete picture of what a different approach would have looked like. As enforcers of the town's bylaws, I would hope that members of this board take some time to sit and read them carefully. One provision stands out, apart from the Track 1 authority of the ACO, as another useful arrow in the town's quiver. Section 1044, which states that each day on which any violation or offense exists shall be deemed a separate violation or offense. The town undeniably knew the dog was unlicensed and unvaccinated from November 19th. Had daily fines been applied at $75 a day from that date through March 17th, the figure on the table at that hearing would not have been $100. It would have been nearly $9,000. Non-payment of bylaw fines carries real consequences, court proceedings, and ultimately a lien on the property. At that level of financial exposure, this situation might well have resolved itself entirely without a public hearing. Under Track 1, as already described, the ACO could have imposed conditions on the owner directly, with input from the LaValleys in writing or not at all, but certainly without them having to appear before this board or be named as parties to a public record as having initiated a proceeding against their neighbor. The dog owner, faced with mounting daily fines and binding conditions, might well have come to this board herself seeking an abatement, ready to comply. This board could have made that abatement conditional on demonstrated compliance with the ACO's Track 1 recommendations, fencing, training, vaccination, whatever was appropriate. That is how Track 1 is supposed to work, but it was never tried. In closing, I'd like to say directly to the LaValleys that you did everything right. You tried to be good neighbors. You documented every incident, sent video, went to the ACO repeatedly, and came to this board when you were told that was your only option, testifying publicly against someone you have to live next to every day. That takes real courage, and you should never have been put in that position. Your family's safety matters, your children's safety matters, and what you have described is real and legitimate and deserves a real response from this town, and I hope tonight brings you closer to that. And to the board, what the LaValleys deserved from the start was a town that used the full weight of its enforcement authority on their behalf, quietly, effectively, and without requiring them to carry the case themselves. The process that led to the March 17th hearing did not give them that. The notice to the dog owner was deficient. The hearing was never announced as a dangerous dog hearing pursuant to MGL Chapter 140, Section 157. The governing statute appeared in the board's packet, but there's no evidence it was provided to the dog owner. The town's bylaws were not in the packet at all. The ACO stated that education and citation were the only tools available and that the hearing was the next step, which is not accurate. The violations for an unlicensed and unvaccinated dog, undeniably known since the 19th of November, totaled $100 only and issued after the hearing was already requested and not even yet due at the time of the hearing. The LaValleys did everything right, the process did not. They came here seeking help, were directed into a citizen-initiated public proceeding against their neighbor, and are now named parties to a permanent public record. A record that also officially documents that their party abuts the home of a dangerous dog, which is not without consequence for its value. I hope this board will ask tonight whether a different approach, one that uses the full range of tools the bylaw provides, and is more aligned with how such matters are handled in other municipalities, would have given this family the resolution they deserved without ever having to appear before this board. And I guess after what the ACO said, I would add that to Justine, if she's listening, that I have resources and I can help you if you need help. Thank you.
Thank you. Next, we go to the complainant, Matt and Christina LaValle.
So thank you, and thank you for that statement. Yeah, so the pictures that we sent in, that we did see the dog loose a few times, and you know, my biggest concern was the dog being loose down where the kids get off the bus. You know, I know Justine says that the dog is friendly, maybe to her, but you know, it's bit my child once on my property, on my private driveway, where he was bit, and my kids are still terrified of that dog. And it's not a small dog by any means. You know, it's a dangerous dog, and it could do real damage being off the leash, and especially without any rabies vaccination at this point as well. It's even worse. So the evidence we did send in, right, is our biggest concern was that dog was loose, and she's just not following, you know, the violation of the dangerous dog.
And I honestly, all we wanted is our kids to be safe. That's it. We would have never brought this again if the dog was on a leash. This has caused so much stress on our family. I don't want it to keep going at all. I also don't want anything to happen to her dog. All I wanted was the dog to be kept on a leash. That was it. And I would have been happy. I don't know. I feel terrible. It's a bad situation.
Well, thank you both for your testimony.
Yep.
Board members, questions, comments, concerns? I think I do have one, and just kind of listening to the dog officer, the animal control officer, sorry. Hearing was in March, they were notified, no substantive proof of rabies, no fines paid. And we now have this evidence taken of the dog being off leash on the property. Has the owner been, I don't believe, if my memory serves me, and please correct me if I'm wrong, was the owner here at the first hearing?
No, she was not.
She was not, okay. And she's not here again today. So I do have concerns with this order not being followed, which is why we're here this evening. Any board, I guess, where do we go from here? Like, what are our options?
So the options, it's up to you guys. My suggestions, when we spoke to Justine LaValle, she just right off the bat wants to rehome Faith. She wants her to be able to be out running. The options that I came up with, if she wanted to keep her, is she needs to build a 4-sided kennel with a roof, and it has to have a dig-proof bottom as well. It has to be a minimum of 10 foot by 10 foot, has to follow all the regulations. I would like it to be some sort of professional rehab training. The rehoming was one of my recommendations. And then just, we have to figure out the stricter enforcement. I have tried quite a bit to work with Justine. I do not want to get into all of that. People's personal business is their personal business. We are trying very hard. I hope something can work in this situation. At the very minimum, if she does want to keep Faith, I would like to see something built, a structure built, rehoming, like I said, that would be ideal, except for the fact it could end up with, you know, euthanizing. That being said, there's only so much we can do. I mean, when somebody doesn't want to talk all the time or, you know, try to work with you, it makes it a little difficult. Unfortunately, as the ACO, we have our hands tied. There's not much we can do. Legally, we do need a board. We do need a vote. We cannot just put orders out there willy-nilly. So that's why we're kind of coming to you, and we would like to hear what your suggestions would be.
Board members?
I mean, you know, even the rabies, there are options that the Board of Health does, not the Board of Health, but makes rabies more available to people who have financial issues. So that could have been taken advantage of.
And we did. I did help her finally when I was able to contact her. I contacted the Petco, told her, well, the Vetco part of it, to help get her going in there. Just like I said, we really, I am more than willing to help in any way I can. I will facilitate anything I can, but it makes it tricky when somebody doesn't always want that open line of communication. So I will do absolutely anything I can to make it better for both parties.
Yes. Yeah.
Now, she said she got the rabies vaccination, but there is no proof.
I just need to see the paperwork.
Yeah.
Can the dog be seized until such time that we get the paperwork?
I don't know if that's really ideal. It's not just that one dog. I have kennel with other dogs, and I think bringing in Faith would kind of upset some other things that we have going on down there. I'm not sure that would be the right solution.
Yeah. Understandable.
I just don't want to, you know, put other things out there that are, you know, what we have going on.
But we look to you as, you know, what you're
I would not recommend seizing Faith down at our kennel right now. I'm hoping to be able to have another conversation with Justine. I asked her to do some research on rehoming. She was going to contact some people. Unfortunately, that did not get finalized before tonight's meeting with her decision. So I do apologize. I can't force somebody to communicate or to make these decisions on unfortunately, our timeline.
But if we put a monetary fine with a deadline that if this isn't done, X amount of fine is applied by a time and date, like a $300 fine will be issued, or maybe if we can't go above that, a $100 fine will be issued every week for failure to not comply. Is that an option?
If I may.
Mm-hmm.
So I can tell you, Ms. Corbo has tried to work with this dog owner as much as she can. Fact that the order is in place, and unfortunately with the dog being loose and going on to the neighbor's property where there's already been a bite, is very concerning. You know, it's a balance as town officials, because obviously we want to work with somebody. This is an order in place, and to not try to follow it, even with the assistance of the town and animal control. We do a lot of things to try to make sure that you know, people are safe, and these localities do express concern, and their obviously concerns are valid. So not having the pieces followed obviously causes the enforcement part of this. We've had dog hearings in the past. Obviously, we've been through several dog hearings. This is the first time that I'm aware that we have an order that is not being followed where, you know, now this is coming back to the board. So this is, you know, this is new for us. And if the owner was present and you could have a conversation, you know, and was willing to work with the town, I think it would be, at least we'd have something to work with. Again, Ms. Corbo has jumped through hoops to try to make it as easy as possible for the dog owner to take care of their own dog.
So I guess when they're non-compliant, what do we have as far as options? When, I mean, they're clearly not following numerous attempts and.
We have a non-responsive owner, and
Right.
we have the order not being followed. I had suggested seizing the dog until such time it is, and that wasn't recommended. The next suggestion I would have is that we do weekly fines for
Along-
non-compliance.
And along with like keeping just the leash part, or adding the structure that the running kennel.
What was the run? Because I know usually when we get these dog hearings,
Yeah.
there's a long list of
Yes.
of items. Did we not go with that on the first one?
We did.
So it's supposed to have a
was-
10 by 10 dig proof.
So Faith, she was to be humanely on a leash, muzzled humanely when she's out off her property, at all times. And that she needed to get microchipped, which did not happen either. Yeah.
She has to be obviously vaccinated and
registered.
licensed just as a
Yep.
minimum
Yeah.
for any
Yeah.
dog in town.
Mhm.
Yeah. So,
And
yes,
what is the fee structure for just she was given a fine? What do you go out when you go out and a dog is not leashed and stuff? What do you issue for a fine? What's the monetary value?
I believe that one is $25.
that goes according to the,
So I guess the question to
Yeah.
the LaValleys who are on here, Matt and Christine, what do you have for suggestions?
I mean, I just want the dog kept on a leash. I don't even think that's a lot to ask.
I would agree. I'm just trying to figure out a way to do this with a non-responsive owner,
Right.
and, you know, I hear you, I agree with you. I'm just grappling with, other than us just going and taking the dog, how else are we going to do this?
Which I have to stress, like, I feel like that has to be a last resort. I do not want anything to happen to this dog because I don't blame the dog for it being off the leash. And I've said that to Justine, like, the last thing I want, and I promise her that I don't want anything to happen to your dog, but at the same time, like, my family has to come first. Like, my children's safety and their well-being has to come before that. I would feel more comfortable with it having to be in a contained area, where there's like no possibility that it can't even be like on leash. It has to be inside somewhere. So like it shouldn't even be a concern for my kids that they'll like see the dog being walked. Like,
I mean, so far,
I don't know. I wish I had a good.
we can't even contain it to a leash, have a $100 fine, have it microchipped. I don't see, I'm not very confident that it would be a cement slab dig proof 10 by 10 with a roof on it now.
right.
I know.
I don't see that as happening.
May I ask Christina a question?
Sure, please.
Okay. Am I correct? I'm not sure. I know my last visit there last week, I believe. Is there already a kennel in the back, a chain link one?
I don't know.
Okay. I couldn't fully see it. It looked like a possible fencing in there. But I didn't get to get a look at it, so I was just curious if there was already one that could be put in here to utilize it.
Oh, I don't know.
Ms. Coyle?
So, for the order that you have in place, if the owner is not willing to work with the animal control officer and not willing to follow the order, we could go through a court proceeding. You know, we could contact counsel to bring this through the court process. I do think that your suggestion for fines is another option.
My concern is that will go by the wayside too.
It
Correct.
could,
Yeah,
I
Since
don't.
they're
but
non-responsive.
it is a process.
yeah.
I mean, it's been over a year.
Yeah.
Is there, you know, a town level, but is there a state level, like state animal control or some, like, above us that can intervene?
I think this is handled at the town level.
It would be us.
Okay.
So, I mean, you voiced concerns over housing at our kennel. Is there another kennel that we can seize this dog and bring it to that until such time she comes into compliance?
The issue is the bite. A lot of places will not hold a dog that bites, and that was my concern with the dog being rehomed. We're probably looking at, honestly, euthanization. So that's the big concern. A lot of people would not be open to doing that. I have talked to a couple of people that I do use to help rehome, and I've gotten the same answer of euthanize. So unfortunately, that's why I'm trying to. I know Matt and Christina don't want to see anything happen to the dog, so I'm trying to get creative. That's why I've been really working hard. I really thought Justine was going to come tonight. So I'm just trying to make them both happy, but number one, keep the kids safe.
Sure.
So even if the board ordered the dog to be seized until such time that the owner could adhere to the order, you're saying that it would probably be difficult to have a kennel take a dog with a dog bite history.
Yes.
And what exactly is going on at our kennel? That
Right now,
there's no room, or
we're a little low on room. I have, unfortunately, some people in town that need safekeeping holds for their animals due to medical issues. So we're fairly small. We only have 2 large kennels that could even house this dog, and I just picked up a 100-pound puppy today. So he definitely needs to stay in a big one. So we're limited on especially large areas for large dogs. Faith would not be comfortable in a small spot, which we are unfortunately low on. We can only house 7 dogs at a time. And honestly, even if we could, I think it would still be the same path.
I mean, I think the only thing we're left with is a recurring fine until, and you know, we take this up each meeting to see where we're at, and if there still is non-compliance with this, then at some point we're gonna have to take the dog.
I mean, I definitely think we should look into legal counsel, see what maybe their suggestion is.
I mean, I don't know how experienced. Yeah, I mean, I just, I don't know. I'm hearing there's clearly an issue,
Yeah.
and I'm just not seeing any substantive solutions. She's a non-responsive owner. She hasn't done anything in a year.
Would the board want to consider continuing this hearing? And we will get information for you.
It can be brought to a magistrate if you would like to have that option.
So we could get information from legal counsel on what their advisement would be, and if you wanted to institute fines, you can do that.
I mean, I don't know if we need to, can we just bring it to a magistrate? Or do we have to go with legal counsel?
I can find out.
Okay.
I don't want to give the wrong answer just in case.
Mr. Matt and Christina LaValle, you've heard like that suggested. I mean, you've been attentive. You see what we're up against here. Is that an acceptable option, at least for now, to explore? You know, we'll do the weekly fines, and then try to keep communicating until our next meeting. Figure out what exactly we can do at the state level, magistrate level. But again, I don't see any other option here. At some point, whether it tonight or next meeting, someone's going to have to take this dog at some point. Unless she comes here and there is a complete resolution of this, which I'm not confident on.
I do just want to be transparent. It will end up probably being euthanized. And I just, that's also why I'm coming here and explaining it, because I don't want it to be a situation where we're going to find this home. So far, I have not had luck.
And she's given us no options.
Correct. And that's,
And if that is an option with this euthanasia, which I am dead set against, but at the
Yes.
same time, it's through no fault of our own either.
correct. No, I just want, because I know that's not what Matt and Christina want. I know that's not what Justine wants.
Nor do we, but we have a
no.
non-compliant person
Right.
that is doing nothing about the
Right.
situation.
And ideally, I mean, I would just love a structure to be built, and we're just gonna follow the orders. We're just not there.
And I think maybe explaining to her in very finite detail, this is where we're at.
Mhm.
The dog is likely unhomeable. That will likely result in euthanasia. I mean, she needs to be in compliance, plain and simple. It's been over a year. We have a young child that's already been bitten. And we now have proof that she's not following the order, and what I don't want is for something catastrophic to happen with another body.
Correct. Correct.
Even more concerns me is the dog being off a leash and in not only in proximity, but now at a bus stop where there's a lot of children.
Correct.
Yeah.
I mean, it's,
So, does that sound like an option, Mr. and Mrs. LaValle?
Yeah, I think so. I think it gives like kind of one last time to try to figure this out and put it on her, and hopefully we see something different.
Okay. So I guess I would, I'd entertain a motion that the board find this dog, this owner non-compliant with the previous order. And seeing that she is going to receive recurring fines weekly until these orders are met. If at our next scheduled board meeting they are not met, then we will be looking to likely seize the dog to bring her into compliance.
One suggestion, I think the fines actually can accrue daily. So we can, if the board wants me to, wants to identify what the fine is, or I think it's a sliding scale.
can we go back to the day where it began the non-compliance?
It's a whole year.
Oh.
$9,000 is what this woman had stated.
I think you had identified that it was first sent to us from the LaValleys, the neighbors, January?
This year. Yes, this year. It was actually January 1st. Was
So that's the first proof we had. Well, no, we
Yeah.
have proof going back because she hasn't licensed, she hasn't registered, she hasn't been euthanized. So no, I would take the position it goes back a year. She hasn't come in for anything yet. So I'll keep with the motion of weekly, in case there is an issue here, and then we, again, certify, visit, explain.
May I also request that the 10 by 10?
Oh,
kennel-
please, yeah.
Okay, I just wanted that, because that wasn't in, I believe that was not in the first one, and I really would just,
Yeah.
I would love for the dog to be okay, and if that was something that could happen,
No, I agree, like,
Okay.
anything we can do to not go with the option that I think is unfortunately gonna be the result of this,
yeah.
I'm all for, but at the same
Okay.
time, it's been a year, here we are,
Mhm.
nothing's been done. We have to take action before, again, something more catastrophic happens to anyone else. So it's, unfortunately, we're being put in this situation to do this, and we have to take these steps.
If I can
Yep.
suggest for the fine amount, if we could have it follow the bylaw.
Okay. So I'll withdraw my previous motion and then restate it, is that we find the dog, I entertain a motion that we find the, Miss LaValle, the owner of, so Justine LaValle, remaining in non-compliance with a dog order, since March 17th, 2025. There was a preponderance of evidence, finding this tonight, so she's in non-compliance. She will receive fines appropriately delineated in the town's bylaws, issued by animal control officer. We'll recommend further steps to becoming in compliance, up to and including the 10 by 10 structure that you would recommend. Minimum, and we will also inform her that she will give it, that we gotta give it the deadline for becoming in complete compliance with the previous order is to be no later than our next board meeting. And if at that time, nothing is still non-compliant, non-responsive, then seizure. Is there a second?
I second the motion for. Want me to
You don't have to,
restate? I second the motion.
Mhm.
I'm sorry, just for clarification,
Sorry.
or do you want the fines to start when the order was put in place, or as of January 1st? Or starting tonight?
I mean, I would say starting tonight,
Yeah.
Okay,
just
thank you.
because, I mean, if we
I
go
just
to
wanted-
January, I would just say starting tonight.
That's fine. Thank
Because
you.
that's, we're here tonight. Because again, it's gonna be cost prohibitive going back a year.
Yep.
So, yeah, starting tonight.
Thank
So-
you.
So we have a motion and it is seconded. All those in favor signify by saying aye.
Aye.
Carolyn Westerman.
Sorry.
Carol Westerman, I'm sorry.
Aye.
Carolyn Griffin.
Aye.
Eric Hodgson, aye. The motion passes. All right. So at least we have a course and an end date for that. So is there a motion to close the hearing?
I make a motion to close the dangerous dog violation at 29 Cedar Street.
I second the motion.
All those in favor signify by saying aye. Carolyn Griffin.
Aye.
Carol Westerman. Eric Hodgson, aye. Hearing is now closed. Thank you all. 6:30, quite late here, the fee schedule, is that something that, it was just kind of a point of, just kind of,
Yeah, so, it's not an urgent matter. If it's something you want, continue to the next meeting, that's fine. I wanted to, just provide to you, this was for discussion. Board members. So this is, for the Board of Health fee schedule. We are, looking at, the fees. The fees have not been updated for several years, so I think it was like 6 years ago. So taking a look at other towns' fee schedules, we have some suggestions here. It give you an idea to kind of review it, and we can discuss it at the next meeting. for any changes. Thank you.
And then we have townwide cleanup event, 5/2/26. There is a packet here in us, so the townwide Saturday, May 2nd, 7:30 to noon. Will be at the fire rescue headquarters at 47 Auburn Street. I know that there's a lot of civic organizations that go to that. And something that, certainly donation of a lot of items too is super, super helpful and beneficial too, so.
Yeah, so we've actually added, each year that we do this, we have, this is a partnership with Chamber of Commerce. So each year we try to add one more item that people can get rid of. So we have fire extinguishers being added this year. So we're pretty excited about it. If people are interested, they can go to the town website and they can sign up. If you don't, if you don't register, you can still come and participate. It's an awesome day, and we have a lot of it's a great feel-good community day. And there's a lunch, like a free bag lunch for volunteers.
And then office updates with the town report and budget process.
Sure, yeah. One thing I did want to let you know, we do also have Household Hazardous Waste Day. We got to save the date for June, so it's the first Saturday in June. So we'll have more information for you at the next meeting, but just to watch for that. We have yard waste collection. You have a little flyer in your packet. That is coming up in April, so about a month from now, we'll start the collection. We do 5 weeks of collection. Town report, I just wanted to let you know, town reports were submitted. Budget process, we just completed the budget review with Finance Committee and also with the town manager. And then we had a really nice Citizen Leadership Academy last week. We actually had 2 nights for DDIS. It was really, it was actually very nice. And, we had participants that were really excited about our presentation. So I just wanted to let you know that was something positive.
All right, communicable diseases.
Nope, we,
Nothing?
nope.
Okay, great. That ends the agenda. Is there a motion to adjourn?
Make motion to adjourn today's meeting?
Is there a second?
Second.
And all those in favor signify by saying aye. Carolyn Griffin.
Aye.
Kara Westerman.
Aye.
Eric Patterson, aye. Meeting is adjourned. Thank you all.
This